A warm welcome to all of you to the webinar series hosted by Advocates Association Bengaluru. We have with us today Mr. Shahbaaz Hussain, Advocate High Court of Karnataka. Sir Shahbaaz, we are happy to have you with us today. Welcome to the webinar.
Thank you, sir. My privilege.
Time to introduce our today's speaker, Mr. Shahbaaz Hussain, graduated from Symbiosis Law School, Pune, with degrees in Business Administration and Law. He had worked with Thiru and Thiru law chambers, and after which he started his independent practice. He has represented KPTCL ESCOM before the High Court of Karnataka, Karnataka Electricity Regulatory Commission, and Appellate Tribunal for Electricity. His main areas of practice includes corporate law, energy law, contracts law, intellectual property law, just to name a few. He has published his articles in noted legal journals and websites. Mr. Shahbaaz, on behalf of Advocates Association Bengaluru, I extend a warm welcome to you. Over to you.
Thank you. Thank you so much, Trivikram sir, for the warm welcome. It's an absolute honor and privilege to be on this show and speak on this webinar. At the outset, I would like to congratulate and express my gratitude to Ranganath sir and all the members of Advocate Association for organizing such a brilliant webinar, which has been very informative and enlightening for the legal fraternity and various other participants who are on this webinar. So to begin with my topic for the day, it is evolution of privacy law in India. Now, the privacy law in India is not codified into any one particular statute or has not been legislated by the parliament in any manner as on the date. The privacy law in India is spread across various sectors and it is highly unorganized. So to touch on every sector where the privacy law has been recognized or the provisions regarding privacy law have been provided will be difficult to cover in 1 hour's time. Therefore, I'll be providing a comprehensive picture of how the laws around right to privacy have evolved in India and what is the stand as on the day. To begin with, the privacy law in India is a very novel concept. For the most part, for the most history, the longest part in India, privacy has not been recognized as a matter of legal right in India. It has always been an equitable right. It has always come under common law. There has been no statutory protection provided for individuals whose privacy is being breached by one act or the other. Now, in this backdrop, the legal maxim damnum sine injuria applies to the privacy law. This maxim essentially means there are damages without any legal injury, which applies in the case of breach of privacy as well. So breach of privacy results in damages to that particular person in one way or the other. Depending on the person and situation, the damages may differ, but the damage does occur to the person whose privacy is being breached. However, the same has not been recognized as a legal injury for the longest of time. Thus, when an act is not recognized as a legal injury, it cannot be tried in a court of law. It does not amount to or tantamount to a cause of action which can be tried in a court of law. So therefore, privacy law at best has been an equitable relief in the courts of India for the longest times. As I said before, there is no codified law on privacy in India, barring few statutory provisions which provide for protection of electronic data, also known as e-data. So these provisions have been provided in the Information Technology Act and the Information Technology Rules 2011. The IT Act, though it came into force in 2000, initially with its inception, it did not have any provision for safeguard of electronic data. After an amendment in 2008, there were few provisions that were included in the IT Act, Information Technology Act, wherein the data protection provisions were provided. And subsequent thereto, IT rules have also been enacted by the Government of India in 2011 under Section 43 of the same Act, which also provide for certain rules regarding the data protection. Apart from this, we have some sectoral protection as well. For example, in the telecom sector and in the finance sector, any entity or commercial entity which seeks to provide services in these sectors needs to be licensed by the licensing authority. And one of the conditions of license under these sectors is that whatever information that you are collecting of a consumer or user of your services, such information has to be protected at all costs. and shall not be disseminated to any third party without the prior approval of the person who's providing such information. So therefore, there are some references where the data protection has been enacted in India, and of course there is Aadhaar also, which I'll talk about a little later. Now, when it comes to private transactions, that is between uh, two private actors without any state actor being involved, it is completely unregulated in India. So what happens here is that parties are free to determine the terms of privacy as they wish. So there is no set rule that you have to go this way or that way. It is completely left to the discretion of the parties, depending on their mutual agreement, how they want to treat the privacy aspect in their exchange of information. So if the parties choose to protect the exchange of information, then they can execute the well-known agreements like confidentiality agreement or non-disclosure agreement and protect their rights to privacy. And under such agreements, they can provide that whatever information is being exchanged in any given transaction shall not be used or shall not be communicated to any third party without the consent of the party giving such information. So however, so what this essentially means is unless otherwise stated in a contract, the right to privacy is not an inherent right. It has to be stated in a contract. If I can draw an analogy here, in contract, there are provisions for gratuitous acts. So it is presumed under law of contract 1872 that unless it is stated to be a gratuitous act, the act will not become gratuitous. And depending on the circumstances and evidence and the facts, the court will decide whether it's a gratuitous act or not. But there's a presumption that it is not a gratuitous act unless otherwise stated in the contract. Here it is the opposite. Unless otherwise stated in the contract, there is a presumption that there is no right to privacy. It is not the case that you have an inherent right to privacy and you have to state in the contract that there is no right to privacy. It's not like that. Here, the presumption is that there is no right to privacy unless you state it in the contract that there is a right to privacy in a given transaction. So that's how the laws work in India as on the date. And it is left completely open to the parties to decide on the privacy aspect. Now, coming to the laws, as we all know, India heavily relies on the international laws, especially when it comes to humanitarian principles and when it comes to novel concepts like intellectual property rights. Like I said, the privacy law is also a novel concept in India, and India is relying heavily on the international laws to come up with a bill and enact a law for itself. I'll talk about that bill that India is going to enact in a while. But before going on to the laws of India, let me just give a brief of two major international jurisdictions and how they deal with the right to privacy aspect. So I'll be covering two jurisdictions here. One is USA and other is Europe. So when it comes to USA, the government in USA and the constitution in USA believes in giving absolute freedom to the citizens of US without any restrictions. So in India, most of the fundamental rights in the part 3 of the Constitution of India carry certain restrictions that can be imposed by the government by following the procedures laid out by the courts over a period of time. Now, however, in US, they believe in giving absolute liberties to the people, and people regulate themselves when it comes to the private transaction. And the same stays true when it comes to the privacy law as well. In US, the government does not interfere at all and does not provide right to privacy as a inherent right in a private transaction. They just leave it open to the public to decide whether it is to be taken as a right or it is not a right in a given transaction. So why they do this why they've gone about doing things in this manner is because right to privacy somewhere runs in conflict with right to expression as well. If I have some information about some other person, and if I want to express that information to someone else, and that will of mine to express that information to some third party is being curbed on the ground that someone else's privacy is being infringed. So so there is a conflict between right to expression and right to privacy. And taking this into consideration, the US has left it open to the public to decide whether they want to go ahead with right to privacy or not when it comes to the private transactions. However, when it comes to state instrumentalities in US, it is very strict that any data of the US citizens, once it goes to any state body for any government work or for processing, they take utmost care to protect the confidentiality of the data and to ensure that the data is not divulged to any third party. They take absolute care, and in the event it is divulged to any third party by negligence or anything, the citizens of US have a great remedy against that in the courts of US. So US, when it comes to the private transactions, adopts laissez-faire approach, which basically means let it be. They just let it be to the people of their country to decide how they want to go forward. Now coming to Europe, Europe has a much more comprehensive law on right to privacy compared to US. Unlike US, the US unlike US, the European regulations in 2016, which are also known as General Data Protection Regulations, GDPR in short, these regulations provide for a comprehensive protection of data when it comes to any transaction, be it a state transaction or a non-state transaction, government transaction or a private transaction. So there are certain rules that have to be followed. Now, India is tilting towards the European regulations, and the bill that India has proposed as on the date is more on the lines of the GDPR regulations that have been accepted in Europe from 2016 onwards. The right to privacy, basically in the present era, is primarily referred to the confidentiality of the electronic data. Anywhere in the world, when we speak about privacy, everyone refers to the privacy policies that are there on the website, the exchange of data electronically on mobile, on laptops, or through virtual assistants, anywhere. So our data, when we surf the internet, use the mobile apps, or even use the virtual assistants like Alexa and Google Home, is getting stored and collected, and it may be disseminated or divulged to any third party, which is not within our control. So therefore, in this context, right to privacy is largely catering to the field of electronic data and not to the data otherwise. However, when we talk about privacy in this particular talk, we are not just referring to private electronic privacy alone. So the data which gets stored in manual form also, not electronically in any form. Basically, any information which gets transmitted and which is private in nature about a person, and such transmission of information is infringing the right to privacy of that person, affects the laws of privacy. So there are two aspects here: one, electronic privacy, and second, the privacy otherwise. So I'm going to divide this talk into two headings: one, electronic privacy, and second would be privacy otherwise. Now coming to the first topic, which is electronic privacy. This is Electronic privacy is a very trending topic around the world. Every country in the world right now is talking about privacy, electronic privacy, and to ensure that our data is protected. This is for the reason that we are we are at a very fast pace moving towards a digital world. We are transforming from a manual world to a digital world, and that pace is alarming. Everything that we do in the day-to-day life is being replaced with a digital mode of transaction. And that, for example, e-commerce is highly prevalent these days. We don't go out for shopping as much as we used to. We don't buy groceries. We just buy it from the phone, and we don't ask for address anymore. We just ask for location over WhatsApp, and we travel to that location using Google Maps. And everything is being done through electronic media. So therefore, when so much of our information is getting stored, we are basically naked in front of that machine which is storing our information, and we are very transparent, and that data can be used in any manner, and it may be detrimental to our interests or may not be, but still the data may be used to the benefit of some third party without our knowledge. What happens in most of these apps in social media is that they pick on what kind of ideologies you have, what are your preferences, what are your dislikes. If you spend 5 seconds on a particular ad, the artificial intelligence of the given website or the given app records that you have spent 5 seconds on this ad. Then subsequently, if you spend about 8 to 10 seconds on a different app, again, the artificial intelligence records that you spent about 3 to 4 seconds more than the previous ad. So therefore, it records that you are liking this ad compared to that ad. So there are discernible patterns which such websites record, and they use it to their advantage. it's not all bad when it comes to electronic data and so much data getting stored. There are certain positives as well. The positives, like if every time you are getting a laboratory test done, it is getting recorded in the app if you do it through the app. And next time you want to do it again, the previous history of your laboratory reports and doctor consultations show up. So it becomes much easier for the doctor to whom you go to show all the laboratory reports and everything. And financial frauds can be detected by seeing the way of transactions that you're doing. If you have never done a transaction on a particular website that appears dubious, but one day you go on to do a transaction on that website through credit card, you will get a call from the credit card from the given bank stating if you've done the transaction or not. So these are some advantages that you can get. So if you're booking Ola day to day, in day-to-day life, if you're from home to work, if you're taking Ola daily, so next day again you don't have to feed that information in the app. It will prompt on its own that you are likely to go here. So all these things are some benefits also. So we need to strike a balance between the pros and cons, and try to protect our data, and at one hand, and on the other hand, we also need to ensure that we get the benefits out of this. Now when it comes to the laws around this, we have Information Technology Act, like I said, which was amended in 2008, and the primary section which talks about data protection under Information Technology Act is section 43A of the Act. 43A was inserted by 2008 amendment, prior to which it was not there. Now this particular section speaks about what will happen when a body corporate owns a data, it handles the data, and it processes the data. A duty is cast on such body corporate to ensure that the data is protected and it is not leaked to any third party. In the event it is leaked to any third party, fine or damages are to be imposed on the body corporate who was owning and handling such data of any given person. No upper limit has been prescribed in section when it comes to the damages that can be levied. So it is to the discretion of the court. Depending on the facts, the courts can decide the damages that are to be levied in the event the data is being leaked. But when I talk about data in this section, they refer to sensitive personal data, not just data, not just any data. It only concerns sensitive personal data. This is the term that has been coined. Any other data can be disseminated to any third party, can be circulated, can be transmitted, no issues as per the IT Act also. But when it comes to sensitive protection data, also known as SPD, these strict measures have to be followed of security, and you have to ensure that this is not circulated in any manner to any third party, and it is not leaked. And in the event it is leaked, damages can be imposed on you by the competent court. Now there are three aspects in this section. One is body corporate. What is the meaning of body corporate? Second, sensitive personal data. What is the meaning of sensitive personal data? And third would be reasonable security practices and procedures. So we need to ascertain what these three definitions are. So when it comes to body corporate, it essentially means any entity, whether joint sole proprietorship or a partnership or a company or any entity for that matter, which is engaged in a commercial activity, is one, body corporate. Second, when it comes to reasonable security and procedures, it states that such procedures that are required to be incorporated for protection of data should be incorporated. And if such procedures are given in the form of a contract between the two parties, then such procedures have to be compulsorily implemented without any variance whatsoever. However, the section also goes on to state that the central government may further provide or elaborate on such security practices and procedures that are to be adopted by the body corporate. And third is sensitive personal data or information. Now, again, sensitive personal data or information has not been defined in the Act per se, but it has been left open for the Government of India to form rules. Subsequent to this section in 2008, the Government of India has formed rules in 2011, which are known as Information Technology, Reasonable Security Practices and Procedural and Procedures, Sensitive Personal Data or Information Rules 2011. Now, these rules concern only sensitive personal data and not even personal data. So I'll tell you what you mean by sensitive personal data. So this particular rule defines what is a sensitive personal data. It essentially means password of a person, The financial information such as credit card, debit card details, the CVV number, the expiry date of the cards, the physical, psychological, and mental health condition of the person who's giving the data, the sexual orientation, the medical records and history, and the biometric information. These data have been classified as sensitive personal data. And when it comes to these data, the section 43 will be applicable, and whether there is a contract between the parties or not, the body corporate who gets hold of this data is obligated to provide security to the person who's giving such data, and such data shall not be leaked. It will be the responsibility of such body corporate. Now, these rules further provide that it is mandatory for such body corporate to have a privacy policy on its website and to put it in a conspicuous place, not in a place that cannot be seen. It should be in a place that is easily visible and which can easily be accessed by a person. And this privacy policy should contain in detail how the data is going to be stored and how it is going to be processed. And if at all it is going to be transmitted to a third party, for what purpose is it going to be transmitted? And what is the use of this data? Until what time are they going to keep this data? All these details should be forthcoming in the privacy policy. Once these details are shown in the privacy policies and it is read by the person who is using that website, then the consent of the person should be taken in writing. It can be through fax or through email, but it is mandatory that the person who has read the privacy policy shall give consent to those terms in writing. Only then it becomes, and this section comes into play, otherwise not. Otherwise, the body corporate cannot use sensitive personal data in any manner for any purpose. Now, the other thing, the privacy policy should be very clear on the objective of such data, and the data shall be used only for that objective alone and not for any other purpose. Also, the person who's providing the information has also been given the right to review that information at any time, go to his profile and edit the information. If he feels that he has given some incorrect information about any of his data, then he has the right to go to the profile page and do the correction at any time that he wills. Once the purpose for which the information has been gathered by this body corporate has been served, the purpose has been met, then it is mandatory on the body corporate to destroy the data, erase the data. Then the other thing is that the provider of information can withdraw such information, sensitive personal information, at any time. At any time, the provider can state to the body corporate that I do not wish to continue with this information being in your hands, and I wish to withdraw the information, and they can withdraw the information. The third aspect now under the rules is the measures for protection of the body corporate. The government of India in the rules state that all such measures that are absolutely necessary for protection of data from the technical point of view should be taken by the body corporate at any cost. In the event there is a theft or there is a leakage of data, then the burden of proof is on the body corporate to establish that they have taken the necessary measures, despite that despite such necessary measures being taken, the data got leaked and it was due to a factor which was beyond their control. So if they could, the burden of proof essentially is on the body corporate to establish that it was not due to their negligence that the data has been leaked. So this is the only primary section in the IT Act which essentially deals with data protection. Then we have section 72A of the Information Technology Act as well, which states that if there is a contract between two parties on electronic data for non-disclosure and confidentiality, and if that contract is breached, and if the privacy of one person or confidentiality of the information is breached, in that case, the person who is breached shall be liable to pay a fine of rupees 5 lakhs or can be punished up to 3 years or both. So it's a penal section which provides for the exact punishment that can be levied. So in the event there is a breach of non-disclosure agreement concerning electronic data, then the upper limit of the liquidated damages is already given in this section. It cannot be beyond 5 lakh rupees. Then there is section 66E of the IT Act, which prohibits capture and publication of private area of a person without his or her consent. After this, there is an exception provided in the same act, which grants exception for the government to access such data under certain circumstances. So the government has been given free hand under the IT Act to access such data from the body corporate without the person who's providing such data being aware of it. So what are these circumstances under which the government can access data? So these circumstances are the sovereignty, if it is in the interest of sovereignty and integrity of India, defense of India, the security of the state, friendly relations, friendly relations with the foreign states, for maintaining the public order, or for preventing commissioning of any offense, or for investigation of an offense. If the government is satisfied that for any of these reasons, it is necessary for it, it is incumbent upon it to get hold of the sensitive information of a given person, then it can mandate that body corporate to furnish such information to government, and it would not be unlawful and it would not be breach of any privacy. So that's about it. Except for this, there are no laws in India which talk about data protection. This is the limitation of laws in India when it comes to data protection, nothing beyond it. So there are a lot of limitations of the Information Technology Act itself when it comes to protection of data and privacy, electronic privacy. The main reason why we cannot go ahead with the Information Technology Act is that this is not an act for the purpose of privacy. This was never meant to be an act for the purpose of privacy. This act governs the regulations around the transactions that take place on internet, this is information technology, and the cyber fraud and all such things. This is a comprehensive law which deals about the overall regulations concerning information technology. The objective of it has never been to protect the privacy of a person or to protect the data of a person. We can understand this from the fact that up to 2008, there was not a single provision in the IT Act which spoke about protection of data. Absolutely nothing, zero. Only in 2008, certain amendments were done, and whatever I listed now, those amendments were added to the Information Technology Act on the point of privacy. Second, it gives a very free hand to the government without specifying any restriction on government and how it can use the sensitive information. For what timelines can the government use such information? Can the government use more information than what is required for the purpose? All such terms and conditions have not been specified in the IT Act. So apart from this, IT Act is also very silent on the penal provisions, except barring the contractual provisions, which speaks of transgression of a NDA or the confidentiality agreement provides for a 5 lakh rupees fine or a 3-year imprisonment. But apart from that, the IT Act is silent on the penal provisions as well, and it is left to the discretion of the court without any guidelines being provided thereto. Now, these are the laws about the electronic privacy, and the shortcomings of those laws also have stated. But apart from this, there's nothing in India as on the date that speak about the electronic privacy. Now, coming to the other topic which I'm speaking on today under the privacy is privacy otherwise. Privacy which is not in electronic form. So we've seen that the laws on electronic privacy itself are unorganized, but when it comes to the laws on privacy which is not in electronic form, are even more unorganized, are highly unorganized. In fact, there is absolutely no law when it comes to privacy in general. When it comes to electronic privacy, there are some guidelines at least which we can fall back on, but when it comes to privacy in general, there are absolutely no laws, and we are left stranded, and it is left to the equity of the court, the common law principles, to decide whether there is a breach of privacy, and privacy in first place, whether it's a legal right for a person or not, whether that results in a legal injury or not itself is not certain. Now, anything can be privacy. Stalking can be privacy. Following can anything can be breach of privacy. Stalking can be breach of privacy. Following can be breach of privacy. Storing information about a person which is not in electronic form can also be a breach of privacy. So who does all these acts basically in our society? These acts are undertaken by the detectives in our society. Detectives have been prevalent in our society for the longest of the time, and they function even to this date. Any person can appoint a detective to spy on any other person and collect personal data of such person. Now, the detective uses all these modes of intruding into the private space of that target person, and collects the data and sells the data for a consideration to a third party. Now, there are again no laws in India when it comes to the detectives. However, in 2007, a bill was drafted in Parliament. The bill which the bill which one second. I'm sorry, Private Detective Agencies Regulation Bill 2007. So this was a bill that was drafted in 2007, but this was never introduced in Lok Sabha or Rajya Sabha, in Parliament in general. Even to this day, this bill has not been introduced, and this just remains as a bill, and it never become a law, and it doesn't look like it will become a law in near future as well, because there's no discussion over this. So under this bill, privacy has been recognized as a right to, as a valid right and as a legal right, and infringement of privacy has been made punishable with a 2-year imprisonment. But this bill never enacted. It never became a law, and it remains just as a bill. And apart from this bill, stalking, for example, is also a punishable offense under the Indian Penal Code, Section 345D of the Indian Penal Code. But stalking here refers only to a stalking of a female by a male, not vice versa. So therefore, again, there is a shortcoming here. Not every act can be counted as stalking. Only when a man stalks a woman, it comes under the IPC. Otherwise, it doesn't. In this backdrop, it is safe to assume that there are no certain codified laws when it comes to privacy in general. It is all left open to the common law principles of the court, equity conscience of the court, and how court treats any particular set of facts. And it is for the court to decide if a person whose privacy has been breached is entitled to any damages or injunction. Now, in this in this background, Aadhaar was introduced in the country, and Aadhaar resulted in a huge hue and cry in the country, and a lot of people started debating and started targeting Aadhaar on the ground that it violates the right to privacy. The government is going to do a surveillance on every individual, every citizen of this country, and the government is going to keep a tab on every moment of the person in the country, and therefore it violates the right to free movement, right to privacy, and various fundamental rights are violated. Right to life and dignity in general is violated because of this act. So on these grounds, Justice S.K. Puttaswamy filed a writ petition in the Honorable Supreme Court. And when the matter came up before the Honorable Supreme Court, the Supreme Court prima facie formed an opinion that right to privacy shall be a right under Article 21 of the Constitution, which says right to life with dignity. Right to life was read into the dignity aspect of the life. However, the Supreme Court noted that there were two judgments, which is MP Sharma versus Satish Chandra and Kharak Singh versus State of UP. In these two judgments, the Honorable Supreme Court had categorically noted that right to privacy cannot be read into the Part 3 of Constitution, which is fundamental rights. So right to privacy does not fall under any of the fundamental rights of the Constitution, and it cannot be read into it also. So the Supreme Court was faced with a dilemma because these two judgments were given by a larger bench than the bench of Supreme Court, which is dealing with the Aadhaar matter. So the Honorable Supreme Court framed two issues. One, the main issue here was whether right to privacy is a right to can be read into Article 21 as right to life with dignity. One, and second, if the first issue is answered affirmatively and it is said that right to life includes right to privacy, then whether the other provisions breathe such right to life with dignity rights guaranteed under the Constitution. No, this was the first issue was referred to a larger bench than the bench which was there in MP Sharma and Kharak Singh cases. So a 9-judge bench sat on this particular issue and deliberated and gave an extensive, detailed judgment of about 350 pages, and and the judgment in principle stated that right to life includes right to privacy. Right to privacy is no different from right to life. It is as serious as right to life. Justice Chandrachud, on behalf of 4 other judges who were part of the bench which determined this particular case, ruled that to live is to live with dignity. Just to live without any dignity is of no use. To live is to live with dignity, and such dignity includes the right to privacy. The Honorable Supreme Court held that dignity is fundamental and core to all of the fundamental rights of the Constitution. Without dignity, all other fundamental rights cannot be effectively protected or guaranteed for other citizens of the country. All other fundamental rights will be adversely affected if the dignity of a person is not guaranteed under Article 21. The Honorable Supreme Court also held that life and personal liberty are inalienable rights. It further went on to hold that right to life with dignity is not a right created by the Constitution of India. No, it is not a right created by Constitution of India. It is a right that comes with the birth. It is a birthright. It is only recognized by the Constitution of India. It is not a right that is bestowed upon a person by the Constitution. It is only recognized by the Constitution of India. That is the serious nature of this particular right that we are speaking about. However, the Honorable Supreme Court held that like right to life, right to privacy is also subject to reasonable restrictions that can be imposed by the state. As we all know, under Article 21, fair, just, and reasonable limitations and restrictions can be imposed by the state. So, any intrusion into the private space as an exception to the general rule of Article 21 shall satisfy three main conditions laid out by the Honorable Supreme Court in this judgment. First condition is that there should be a law in place, and that law should have been passed with proper procedures, and it should be a recognized law. So, which essentially means it should be a law passed by either by the state assembly or by the parliament, and should have also been notified in a gazette, and it should have been enacted. First condition is that. And second condition is that the law should have a very clear and discernible objective. What is the objective that is being sought to be achieved by such an act or such a law? That has to be very clear, and it has to be reasonable. That is also a condition that has been imposed. And third and most important condition is that there has to be a rational nexus between the object and the means adopted to achieve such object, which essentially means that the intrusion of privacy shall be proportional to the object sought to be achieved by such intrusion. So you are trying to intrude into a private space of a person, and if you're doing so, there has to be a valid basis, and there has to be a proper objective, a lawful objective for that intrusion, and it should be proportional. The invasion into privacy shall be proportional to the objective that you're seeking to achieve through such act. So once you satisfy these three conditions, then you can impose reasonable restrictions on right to privacy under Article 21. The Supreme Court, Honorable Supreme Court further noted that information privacy is a facet of a privacy. It is not a privacy per se, but it's only a facet of a privacy. And such information privacy can be breached by not the state actors, but by the non-state actors. And it was felt that there is no comprehensive law in India which governs the data protection when it comes to information privacy. And the Honorable Supreme Court directed the Union government to come up with a strong law which caters to all aspects of privacy, and which is in conformity with the various ratios and observations that the Honorable Supreme Court has made in this particular judgment. The Honorable Supreme Court further noted that there are two contents for right to privacy. One is a positive content and the other is a negative content. The positive content is that the state should come up with a law to protect the rights of a person when it comes to intrusion of privacy. And negative content is for the state to refrain from intruding into a private space of a person. And the last thing that the Honorable Supreme Court had, the last important thing, there are various things that have been laid out by Honorable Supreme Court in this, but due to paucity of time, I cannot go into every aspect. But another important thing, the thing that the Honorable Supreme Court has held, that when it comes to a personal identity, like for a celebrity, and it can be commercially exploited by publishing at various places. So the Honorable Supreme Court has held that without the consent of that person, a personal identity cannot be commercially exploited. A personal information of of any given person cannot be shared, even if such information is true, because it is for that person to decide whether such information is to be shared with any third person or not. It doesn't matter whether the information is true or not. So even a true information cannot be shared if it's in the private space. So these are the important paramount ratios that were laid by Honorable Supreme Court in this judgment. And thereafter, the matter was again sent back to the original bench of the Honorable Supreme Court, and it was asked to decide on whether the provisions of Aadhaar are in conformity with the right to privacy rights that have been recognized in this particular judgment. So again, the Honorable Supreme Court, after carefully considering all the aspects of the Aadhaar Act and to see what is the level of privacy that is being breached and what is the need for such privacy to be breached, was convinced that this falls under the reasonable, fair, and just exception to the general rule of Article 21. The Honorable Supreme Court held that this is a reasonable restriction that has been imposed by the union and government, and it is a restriction that is necessary in the public interest, and such reasonable restriction can be imposed under Article 21. So the Honorable Supreme Court here on two main aspects. One, Article Section 139 AA of the Income Tax Act was also amended subsequent to the Aadhaar Act to make it compulsory for linking your Aadhaar with the PAN card. So this was termed to be unconstitutional by the petitioners, and it was challenged before the Honorable Supreme Court. But the Honorable Supreme Court noted that there is the duplication of the PAN card in the country is being done left, right, and center, and all the PAN cards are being duplicated in order to evade tax. And this is a known fact. It's a right fact in the country. It's common knowledge. So to avoid that, the only possibility, only action that the government could take is link it with the Aadhaar, which cannot be duplicated, which is unique, which cannot be duplicated by any means, because you get your own unique number and your biometric information is fed into the card, and which cannot be duplicated. So therefore, to avoid duplication of the PAN cards and to ensure that there is more transparency in filing of tax returns, income tax returns, the Honorable Supreme Court held that it's a just and valid restriction on right to privacy, because the objective of ensuring transparency in tax filing is being met through such intrusion. And second thing is, the government said that the government is going to take the data of all the people who are beneficiaries of a government scheme. So without our consent, of course. So again, that was challenged on the ground that without our consent, the government is taking our data. So here also, the Honorable Supreme Court held that any beneficiary scheme of government like BPL cards or ration cards or all these things are being duplicated. The rich or the middle class society in India are duplicating such cards and are misusing such schemes by pretending to be a below poverty line card holder and such things. And so they made it mandatory to link such cards with the Aadhaar card so that they cannot be duplicated. Again, the Honorable Supreme Court recognized that to be a valid objective and said that it's a reasonable restriction. So in totality, the Supreme Court, the Honorable Supreme Court in this judgment held that right to privacy is right to life under Article 21, and the other provisions do transgress right to privacy to an extent, but the provisions fall under the reasonable restrictions that have been provided under Article 21 itself. And even in this judgment, the Honorable Supreme Court has noted that there is a need to come for Government of India to come up with a comprehensive law on this subject. And while this case was pending in Honorable Supreme Court, the Union government formed a committee under the chairmanship of retired Justice B.N. Sri Krishna. And this committee formed a detailed report and submitted it to the government. And after considering the report of this committee, government has come up with a bill called as Personal Data Protection Bill 2019. In 2019, it has been drafted and it has been introduced in the Parliament also. It requires to be passed by Parliament as on the date. It has not become a law, but it is there in the Parliament. Now I'll just talk about I think about 15 minutes are left. I'll try to cover the salient features of this bill in as briefly as possible. Now let's just go with 3 to 4 main concepts that are shown in this data protection bill. The main objective of this data protection bill is that there is no comprehensive codified law in India for data protection, and there was a need, and therefore they've enacted this bill to come up with a single coherent comprehensive law on the point of data protection. So there are 3-4 main definitions that one needs to be aware of when we are talking of this bill. First is data principal. Data principal is a person who's providing the data, who's sharing his personal data. He is known as data principal under the bill. Second is data fiduciary. Data fiduciary is any corporate body or any person who is receiving such data from the data provider, from the data principal. Third is data protection authority. Protection authority is a regulatory authority, which was never there in India before this time, which is the custodian of everyone's right to privacy, which ensures that the data fiduciary, which is in possession of data providers' right, takes utmost care to protect such data. Next is definition of personal data. This entire bill mainly revolves around personal data, and anything which falls under the personal data requires to be protected. But if it is not personal, again, it is beyond the ambit of this bill, and there is no protection for such data. Now, what is personal data? Personal data is any data through which a person can be identified. It can be characteristics, traits, sexual orientation, the geographical location, or the IP address of the computer which he is using, anything, any information through which a person can be identified or a profiling of a person can be done is personal data. It is left open, it is exhaustive, and no inclusive definition has been given. Next, sensitive personal data. I've already spoken about what is sensitive personal data in the IT rules of 2011. On similar lines, again, sensitive personal data has been defined in this particular bill as well. Barring one exclusion, which is password. Password was considered as a sensitive data in the earlier bill, IT bill. However, it has been excluded in the PDP, in the Personal Data Protection Bill. The other important thing that we need to learn about this bill is social intermediary. Social intermediary is nothing but social media platforms like Facebook, Twitter, or anything which meets a particular threshold. The threshold has not been defined in the bill. It is left open for the government of India to prescribe such threshold in the rules which are eventually to be formed. So any social media which facilitates exchange of data between two individuals uh, is required to do a user verification. It has like sending an OTP to the person to identify if the same person is accessing that social media platform, to ensure that there is no impersonation. So it has been mandated that user verification is mandatory on social media. Now there are certain duties of duty fiduciary. First duty is that the data shall be used for the specific purpose for which it has been obtained. It cannot be used for nothing at all, absolutely nothing. It has to be used only for the specific purpose. Even when you're using that data for any other purpose, and such usage may be innocuous, such usage may not harm the person who has provided the data, but still it's unlawful under the bill. It is mandatory that it has to be used for the specific purpose for which it was obtained. Second is consent of the data provider or the data principal is again mandatory. And however, there is again an exception here when it comes to medical emergency or the state beneficiary services like providing ration or anything. Such consent is not necessary. The government can access your data without the consent as well. Third, because when I'm talking about data fiduciary, it is not only a body corporate, it can be a government also. Any body which gains access to the personal data of a person is a data fiduciary. Now, third important duty is collection of the data. Once the collection of the data is done, they store it for a particular timeline. And once the purpose for which it was obtained has been met, they cannot continue with the data. They have to delete the data or erase the data. That is known as the doctrine of forgettability. So you have to compulsorily erase the data after the purpose for which it was obtained has been met, and you cannot continue with it even after the purpose has been met. And second, it has to undertake to provide transparency and accountability. When I talk about transparency, it has to set up a consumer grievance redressal forum, a consumer care center basically, where a data provider at any time can call within reasonable hours and speak to them regarding the data that they furnished and what is the position of the data, to with whom it has been shared, and all such information can be obtained. Or if there is any complaint of the consumer can lodge such complaint with the grievance redressal forum. And when it comes to accountability, uh, all the messages, all the data, all the personal data that is stored has to be stored in an encrypted form. It cannot be stored in the same form that we are giving it. So it has to be stored in such a form that in case there is a leakage, in case there is any hacking or any person has hacked into your database and he has got access to your data, he should not be able to make out what the data is. It should be coded, it should be encrypted. This is also a mandate that has been given on the data fiduciary. Then second, if there is a breach of the personal data, and that is not due to their fault, but due to some factor which is beyond their control, then they should report such breach of personal data to the Data Protection Authority, DPA. But however, again, there is a rider here. You are not required to report every breach of data, but only such breach of data which is harmful in nature. If some breach of data is termed to be or perceived to be innocuous in nature, then it need not be reported. If some data which has been breached is harmful in nature, it has to be reported. So what is harmful? Again, 3-4 guidelines have been given as to what is harmful. Harmful is any financial loss, any loss of reputation or loss of service, or termination from your employment. If these are the repercussions of breach of data, and then it has to be reported to DPA, that is the Data Protection Authority. Otherwise, it need not be reported. And the discretion has been reserved with the fiduciary in here. And this sensitive protection data can also be transferred to any foreign country. There again is no restriction. Again, with the consent of the data provider, of course, it can be transferred to any foreign country. However, with a condition that such data should first be stored in India. As on the date, what is happening is all the data is being stored in clouds, and these clouds are located outside India, are owned by the companies, multinational companies which are not within India. So after this bill is enacted, this will undergo a change. Geographically, such data has to be stored within the territory of India. So these are the main duties of the fiduciary, data fiduciary. Now coming to the rights of the data provider or data principal, the data principal has 3 basic rights. One, he has right to know the status of his data, what is the processing that has been done. Second, if he is willing to withdraw the data, he can withdraw the data, discontinue the data services with any fiduciary. And third, when the purpose is served, he can seek the deletion of the data, which I've already spoken about. Next is Data Protection Authority. Data Protection Authority again is an authority which is a regulatory authority, and any complaint regarding any transgression of the fiduciary in leaking the data can be filed with the Data Protection Authority. But before approaching Data Protection Authority, it is mandatory for the data principal to file a complaint with the data fiduciary itself, and within 30 days, if the complaint is not resolved, then he can file a complaint with the Data Protection Authority. Now, the Data Protection Authority will consist of a chairman and 6 members with at least 10 years experience in the administrative and the privacy field. Now, the grievance redressal also above spoken, it can be addressed to the fiduciary in the first place. And if it is not resolved there within 30 days, it can go to Data Protection Authority. Again, even in this enactment of the bill, there are certain exemptions to the data protection. So I'll speak about these exemptions. So a data fiduciary can go beyond the provisions of this act and use the data without the consent of the data principal if it is required for prevention or investigation or prosecution of any offense, or if it is for personal or domestic use, or if it is for the research purpose, or if it is for the journalism, or if the terms of an employment dictate that such data shall be divulged, then it can be divulged. Then a search engine. So whenever we go to Google and we search anything, it gets recorded. Unless you are on an incognito mode, anything you search on Google gets recorded. Again, that has been exempted under this particular bill. No protection is given there, and such recording has been allowed. And then there is credit scoring facilities like Paisa Bazaar and few other things which give you the credit rating on your credit cards and everything. So these things have also been allowed to maintain financial discipline in the country. However, these purposes should clearly be defined when you are using the data, even without the consent of the party who has given you with such data. Now coming to the penalty is very heavy under the bill. If one gets convicted and for any of transgressions of the provisions of this bills, the penalty is huge. So any company in India, IT company, would think twice before transgressing any provisions of privacy. The penalty is 4% of the worldwide previous year's annual turnover, or rupees 15 crores, whichever is higher. So a minimum of 15 crore rupees has to be paid as a penalty if you do not follow any provisions of this bill. And there is an annual audit also that is to be done by an independent data auditor, not the tax audit, but the data audit. So this data audit should also be done every year. In case you don't do it, then the penalty is 2% of your previous year's worldwide annual turnover, or rupees 5 crore, whichever is higher. Again, a minimum 5 crore rupees fine has been imposed. Second, once a person has been de-identified and his data has been declared to be removed, you have to compulsorily remove the data. If afterwards it is found that you've re-accessed this data, you've stored it somewhere and you're using it again, then you are liable to be punished with an imprisonment which can go up to 3 years, or fine, or both. Another important aspect that lawyers should bear in mind, that to file a complaint under this bill, only the DPA can file. The private person, the data provider, cannot file a complaint in court of law. He has to file a complaint with the Data Protection Authority. After its satisfaction on the authenticity of the complaint, the Data Protection Authority will then subsequently file a complaint in the competent court of law. So this is the bill that has been drafted as on the date. It has not been debated or passed as on the date. However, there are certain criticisms which still prevail on these bills. There are three main criticisms which I'll just speak about in 2 minutes. One, a free hand has been given to a fiduciary, data fiduciary, which is in possession of the data, to investigate an offense. And for this purpose, they can get hold of any data of this person for whatever timeline without any provision of this bill being made applicable. So this is a very blanket exemption that has been provided without any checks and balances. To give you one simple example, under the Indian Telegraph Act, interception of calls can be made. However, the data shall be destroyed after 6 months of use. It cannot be stored beyond 6 months of the use, and it shall only be such data that is required for the purpose of investigation. Only such data shall be obtained under the Telegraphy Act. However, no such checks and balances have been provided in this bill. The government or the fiduciary, whoever it is, for the purpose of investigation, can go on taking any data that it wishes and keep such data in its possession even after the purpose has been filled, because the provisions of these bills are not being made applicable. So this is one criticism that is there. And second, when there is a breach of personal data due to an extraneous factor, it is the duty of the data fiduciary to report such breach to the data provider authority, the regulatory authority. No, this right has been given to the right and duty has been given to the data fiduciary. Now, data fiduciary may or may not report the breach of personal data. Only the data fiduciary will be aware if there is a breach of the data. Why will it go report such breach to a data providing authority, a data protection authority, which can then which can then sanction an data audit on the data fiduciary? And the second thing, it does not augur well for the reputation of such data fiduciary if it reports that there has been a breach of personal data. So the reputation goes down. So there is an inherent conflict of interest when it comes to filing a complaint with the regulatory body on the breach of data, because such complaint is adversely affecting the data fiduciary itself. And third major criticism is that the data fiduciary can file a complaint only when there is a perceivable harm done to a data provider. It should ideally be as per the European regulations and everywhere internationally. Any breach of any provisions of this particular bill, it should be reported to the data protection authority. And whether the breach of privacy is innocuous or harmful, it doesn't matter. Independent of the nature of breach, it should be reported to the data protection authority, is another criticism that is there. Now, this bill, Personal Data Protection Bill, has been enacted on the lines of General Data Protection Regulations 2016 of Europe. This is 2016 GDPR, which are more stringent in nature compared to the provisions of these bills. Now, the European Union makes it mandatory for any company, wherever it is located in the world, if it has anything to do with any European citizen, then it is mandatory for that company to follow these guidelines and be GDPR compliant, without which they do not allow such countries to transact in Europe. Now, what is happening in India, 99% of the IT companies have one or the other business in Europe. That goes without saying. So now all the companies in India are very particular about following the GDPR regulations, which are more stringent in nature than the laws that are there in India. So even though the laws in India do not mandate them to follow these things, but due to their requirements in the European area, it has been mandated on them that they follow this, and they take it very seriously. And as per the reported statistics, 60 out of the 120 countries that are located outside Europe have adopted these regulations. 60 out of the 120 countries. So that is about 75% of the world as on the date is following the GDPR regulations. So when we talk about data protection, it is the GDPR regulation that take prominence from the point of view of the world in general. And in India, when eventually the bill gets passed, it is based on the regulations of GDPR, but may not be as stringent as GDPR, but it is more or less based on such regulations. So this is the status of the privacy law in India as on the date, and we are awaiting the bill to be passed, and we have to wait and see if the bill undergoes any amendments before it gets passed. We can only hope that there is a strict law in India, especially after the Puttaswamy judgment, which recognizes right to privacy as right to life, governing the rights of an individual to lead his life privately if he or she so wishes. That would be it, sir. So I conclude my presentation with this final thoughts. Over to you, Trivikram, sir.
Thank you so much, Mr. Shahbaz, for a intriguing presentation. Now, can we move on to the Q&A session, please?
Sure, sir.
Can we have the first online question? Can we have the first online question, please? All right, I see Mr. Shankar Bhatt raising his hand. We'll start with Mr. Shankar Bhatt. Sir, I have unmuted you.
Yes. Sir is on mute, I suppose.
No. I have given him the option to unmute himself.
Yes, Trivikram, thank you.
Thank you, sir. Please.
We are new to this technology, Trivikram. Thank you, Shahbaz, for your presentation.
Thank you, sir. Thank you.
I was going through this Puttaswamy's judgment.
Yes, sir.
Constitution bench judgment, where they say section 47, where the aggrieved person can complain. Now, in
Yes,
this PDP bill, what we are
Yes, sir.
discussing now,
Yes, sir.
there is a complaint to be given to Data Protection Authority.
Correct, sir.
And then if they are satisfied, then it will be filed by the authority, prosecuted by the authority, right?
Right, sir. Right.
This requires to be corrected, no? That is one issue which I would like to point out.
Right, sir. Right, sir.
I have one more issue, Vikram.
Yes, tell
Yes,
me,
sir.
sir.
See, we are working on Zoom, right?
Right, sir.
See, the moment I open the Zoom box, which we are all discussing in the webinar,
Yes, sir.
I need to give this email ID in the box. Then only it gets connected, right?
Right.
So this Zoom becomes this data fiduciary under the law, right? My email is with them.
Right.
So this is how this entire system functions. Now these all companies like Yahoo, Gmail, and other companies, they have got office in San Francisco, California, New York, and other part of the world. Now on the other day we saw in the newspaper that in Leh, which is part of India, it was shown as a Chinese territory. This is one aberration I would like to share with you.
Right.
Now, how to prosecute them, how to bring them into Indian jurisdiction. The moment you see the Google access, you have to sign the form where you should agree for the terms and conditions there. Now their jurisdiction is agreed to California. How to prosecute them, Shahbaz? Tell me. That's all.
Yes, sir. Yes, sir. So the first issue that you have raised is regarding who can file the complaint. Under the Puttaswamy judgment, the person whose rights are being infringed can file the complaint, but under the bill, it has been stated that the complaint shall be made to the DPA, who will eventually file it to the courts. So, sir, these provisions have not yet been finalized. It can be taken that this particular provision in the PDP bill may not be in consonance with the ratio laid out in the Puttaswamy judgment. So when it is eventually debated in the parliament and passed, this may undergo a change. But as of now, this is the case. But even if it is passed, then again, it is subject to the legal scrutiny and the courts may decide whether that is valid or not. But even if attempting to justify the drafters or the people behind this, They are trying to say that you can do it through a person who is more competent to file such complaint on your behalf. You may not be aware of the exact breaches that you've undergone because you are a layman. So when it comes to this electronic data, this is an expert body, and which can better present the case before the court for the purpose of giving you the damages for infringement of privacy. So that is the first issue, sir. Coming to the second issue of jurisdiction, of course, even if someone is located in San Francisco, US, Europe, it's debated, it's not known if it, we believe it comes in India, Chinese believe that it comes within China. So when it comes to the prosecution in India, we still believe it to be a part of Indian territory only. So we still believe we have access. So anyone who is in lay is amenable to these provisions of PDP and is susceptible to these provisions, and these provisions are applicable on him as well. So, but any company, say suppose Facebook, which is based out of US, but they will still have their officers in India. They'll have their Indian appointed officers or the general managers who will take care of these things. So any representative of their company who works in India can be tried. And if there is no such presence, physical presence in the country, India has not signed any international treaties on the point of privacy. So India cannot fall back on any of these treaties also for extradition or any such cross-border execution of judgments. So, but what India we can do is still, because these websites continue to have their presence in India, it is very important for them commercially to have their presence in India. We can we can take necessary measures to ensure that these websites are blocked in case there is violation of right to privacy as per the provisions of these bills. And these people are not coming forward for a trial and they are staying in US and they're taking refuge in wherever they're staying outside India, then we can always go back to blocking such website in India and ensuring that that a website is not used in India and henceforth. So all these big companies, such difficulties are unlikely to be faced because they have their presence in India, not just in one city of India, but in multiple cities of India. So as the law plays out after it is enacted, there will be more clarity on this. I hope I've answered your question.
Thank you. You can unmute me.
Thank you, sir. Now I'll be unmuting Mr. MVV Ramana. Yes, sir.
Hello.
Yes, sir.
Hello?
You're audible.
Can you hear me? Okay.
Yes.
My question was audible?
Yes, sir.
Okay. This is
Yes,
test what this is a question what I am asking. What a simple test for an ordinary person, not an institution, to identify.
No, sorry, sir, I didn't get you. Come again.
No. What is the test that is available to an ordinary person to know whether his data has been breached? That's number one. And how to identify the institution or the organization which has breached it?
Okay. Sir, you're talking about the data principle under the bill.
Yes.
Who's providing the data.
Yes.
Now, under the bill, there is a compulsion on the data fiduciary, which is owning the data, which is processing the data, to set up a consumer grievance cell. So you as a data provider will have to approach that consumer grievance cell, who will give you the exact status of your data. They will tell you to who all the data has been disclosed. And if that is in conformity with the privacy policies and you're already aware that this data is going to be shared with this third person, then fine. But when you see that the data is being shared with some fourth person, then you can file a complaint with the same consumer authority and try to resolve it within the 30 days. And if you're not satisfied with that resolution, you can file a complaint with the DPA, Data Protection Authority. So the bottom line here is, when you dial that customer care number, they should be able to tell you exactly the status of your data. If they give you any incorrect status, and if you still have doubts on it and you approach the Data Protection Authority and they investigate, they can order data audit. And subsequent to data audit, if it is found that they have given incorrect information to you, they have hidden the fact that there was breach of personal data, then that will amount to transgression of the provisions, and they will have to pay a fine, which is a minimum of 15 crores. So this is the modus that one has to follow.
Okay. Thank you.
Thank you. Welcome.
Now I'm unmuting Mr. Mahesh Babu. Yes, sir, I have given you that option.
Yeah, good evening, sir.
Good
So,
evening, sir.
my question is, so these judges are not that tech savvy to know
Yes,
the
sir.
intricacies of these definitions, different sections of the bill,
Yes, sir.
or
Yes,
about the data protection, or some hacking, spamming, or storage of data.
yes, sir. Yes, sir.
How to rectify this one, or any special courts have to be established, or specialized judges have to be appointed for this purpose? Because
Yes,
in
sir.
future, more and more number of cases will crop up.
Yes, sir.
Yeah. So how to solve this one? Whether CPC or CRPC or in these it is included.
Right,
Any
sir.
provisions are there to try these cases?
No, sir. As on the date, no provisions are there.
Yeah.
So, like I said, under the IT Act, there are some a couple of penal provisions which provide for 3 years, 2 years imprisonment, which has to be filed in a normal magistrate court. There are no separate courts for that. And even in this, whatever penal provisions have been provided, special courts may be provided eventually. As on the date, it's a gray area which even I have identified. The judges who we appear before in the criminal cases may not be tech savvy enough to understand the intricacies of these cases to determine whether there has been a breach of privacy or not, and whether to see that sufficient and adequate security measures were adopted by the data fiduciary or not. So when it comes to these things, it is still a gray area. I hope the government resolves it, and I hope special judges are appointed for this particular purpose. Like how the members of Data Protection Authority, they are experienced, they are special members. So when it comes to penal provisions of imprisonment, I don't know. As on the date, there is no clarity on that if we are going to have special courts or not. But it remains a gray area as on the day, sir.
Yes, sir. Thank you, sir.
Thank you, sir.
Thank you, sir. Next question is an offline question. Under which provision can a data principal seek compensation or remedy for the breach of data?
The exact provision under the bill?
Perhaps, yes, that's an offline question, so I don't have anything more. I repeat the
Okay.
question. Under which provisions can a data principal seek compensation or remedy for the breach of data?
Just a second, sir. I'll have to refer to the data principal bill to give you the specific provision. Under 32, sir.
32, all right.
Under section 32, it may undergo a change eventually when the bill is passed. So that's why I have not been quoting any section as of now. So, but under section 32 of the bill, the complaint can be made.
Right, thank you so much. Can we have the next online question, please? All right, I am unmuting Mr. Harish. Yes, sir.
Yeah, thank you, Trivikram.
Thank you, sir.
Good evening, Shahbaaz. As
Good evening, sir.
a comprehensive the presentation on the three aspects you have done.
Thank you very
On
much, sir.
privacy law, data protection, GDPR, and the new data protection and the IT Act.
Yes, sir.
The IT Act 43, 66, 72. These are
Yes,
the
sir.
three crucial things, sections
Yes,
which
sir.
cover these things. Okay.
Yes, sir. Yes, sir.
The other one is section 69
Yes,
of
sir.
the
Yes,
IT
sir.
Act.
Yes, sir.
Data intersection, to intercept the data, to
Yes,
take
sir.
away the data from the source, including your hard disk, by entering your house on the
Yes,
grounds
sir.
of the sovereignty, safety, integrity of the nation, and friendly relationship with foreign nations and things like that.
Yes, sir. Yes, sir. Yes,
That's
sir.
what it says. They can enter your
Correct.
house and take away the data.
Correct,
Data.
correct,
So
correct, sir.
the government can empower any authority to investigate, enter your house, take away the source equipment, also hard disk, computer, anything.
Yes, sir.
Okay.
Yes, sir.
So
They
that's
can do it.
the law.
Yes, sir.
Okay.
Yes, sir.
So the other issue is this one thing. Okay, how does this work? Who is the agency who is at the moment in charge of doing this one? One, okay,
Yes,
under the IT Act 2008 amendment, and the other three aspects are
Yes, sir.
under the data protection bill. Just now,
Yes, sir.
Mr.
Yes,
Shankar
sir.
Bhatt mentioned about Kutswami's case. Yes,
Yes, sir.
and
Yes,
Google
sir.
and things like that. I agree.
Yes, sir. Yes,
You
sir.
have to accept it before logging into a social intermediary on the websites. Okay,
Yes,
until
sir.
you
Yes,
say
sir.
I
Yes, sir.
accept, I agree to the privacy term, you can't go in further at all.
Correct.
Okay. Okay, so that's in that case, as you said, only Data Protection Authority has the right to file complaint. Okay.
Yes, sir. Yes, sir.
If you look at the same judgment which says Kutswami judgment which says Article 21 includes right to privacy.
Yes, sir.
Okay, that means
Yes,
fundamental right is infringed.
Yes, sir. Yes,
Even if this law says that only
Mm.
Data Protection Authority has the power to file complaint. If my fundamental rights are violated and right to privacy is violated, I have a right to go to Supreme Court directly to restore my right to fundamental right on privacy.
Right, sir. Right, sir.
So how can the Act override the constitutional provision of fundamental right? So that
Right, sir.
lacuna still exists in the bill at the moment.
Right, right,
That has
right,
to
sir.
be cured. One.
Right, sir. Right,
The
sir.
other is social media, this cross-border thing, like
Yes, sir.
mentioning Leh or showing Arunachal Pradesh, part of it as being part of China, which was done on Google Earth. Then when it was taken up by India, it was removed. Okay, when they started issuing stapled visa for people to enter Arunachal Pradesh, this is what had happened quite some time back. Okay.
Right, right.
Okay, if you take up Baba Ramdev's case versus Facebook, okay, using data to make defamatory content being posted on the Facebook. Finally, Delhi High Court ordered in 2019 December, asking Facebook to globally remove all this and locally also to remove all these contents from the Facebook. So such an order can be made even if they are situated in San Jose, Google is in San Jose, Microsoft in
Yes, yes,
Seattle
yes,
and things like
yes.
that. So there is no geographical boundary for a digital arena itself under the digital world.
Correct,
To
correct,
make
correct.
any order,
Absolutely.
Indian courts are competent to make any order to ask them to remove or ask them to erase the data under your section
Yes,
18 of the
yes.
new personal data protection bill. If you see
Protection bill.
section 18, it's
Yes,
asked for
yes.
erasing of data.
Correct,
So
correct,
that
correct.
order can be made from Indian courts, even if they are not a signatory anywhere. You can
Right.
ask them to,
No,
because
that
they
you
are
can
service
do.
provider here. Otherwise,
Right,
like
right,
China
right.
can block Google, China blocked the Flipkart. Only they have Alibaba. They don't have a social intermediary operator
right.
to sell goods on online. So that
Right,
power is
right.
there with the sovereign, because that affects the sovereignty of India, and the people are sovereign under the preamble of the Constitution of India. Okay,
Correct, correct,
sovereignty
correct.
includes the sovereignty of the people who elect the
Yes,
representatives to
yes.
make law and things like that, and their fundamental rights are affected. So that
Right,
sovereign power
right.
can be exercised by the courts even under the Constitution as of now. The other
Right,
one
right.
important thing which I want you to address is data theft by employee. Okay, a person working in a computer or software firm. Okay, and when he leaves the firm, severance of his job from that place. So he will have some data in his possession. And if that data tomorrow, if companies start taking action against this employee, that data theft. See what is theft under the IPC also. Okay, once you take away something, if I steal something from you, it won't be with you. It can't be with you. Whereas in digital world, that is not the case. Data is stored in the backup data storage devices in all the software firms. Even if the employee has some data with him and he shares it outside, how can this amount to data theft? Because the data is there in your backend and storage devices in the company itself. If this lacuna is not factored into the bill, then there will be innumerable data thefts. Cases filed against the employees just because they live out of personal vengeance, corporate vengeance against the employee. When I take away, when a theft happens, the owner cannot have that data with him. Whereas all the digital data are stored in the backup devices in every software industry across the globe. So how do you factor this? Otherwise, tomorrow employees out of vengeance, which is because he left the employment here, or he is being poached by another employer, there can be data theft being filed against the employee.
Right, right. So I believe you've raised 4 particular issues here. The first particular issue is about one of the main issues is who can file the complaint when right to life under Article 21 has been infringed. Then the writ under 32 can be filed in the Honorable Supreme Court, or under 226 it can be filed in the Honorable High Court, and it can be enforced through High Court or Supreme Court. It need not necessarily be protected by the data protecting authority. So, sir, here again, these fundamental rights of right to life and Article 21 is available only if the data fiduciary is a government body. It has also been noted in the judgment of Puttaswamy that these rights are available against a government body, because fundamental rights are enforceable against the government body barring the habeas corpus. So all of the fundamental rights are enforced against the government bodies. So, but when it comes to the private transactions, I still doubt if we can take help of Article 32 or 226 and approach the Honorable High Court or the Honorable Supreme Court. And again, we will still, even if we challenge this bill on the point that not enough protection is being given to us in terms of grievance redressal forum, we may have to wait and see how this plays out. It may still play out as per the report, the justice report that has been, Sri Krishna's, thank you, sir. The Sri Krishna's report that has been filed, and on the guideline, on the suggestions that have been given in this report, this bill has been formed. It may still play out as per their intentions, and it may work out well for the public. We don't know. We will eventually know when the law is enacted and when we see it in practice. And second, when it comes to the cross-border, of course, any injunction can be granted, any order can be granted for erasing of the data or the blocking of the website itself, unless you comply with all the provisions of the bill or satisfy us that you have done this. So we were talking in the context of securing the physical presence of the person who is responsible for the breach of data for punitive proceedings, for the criminal case to be held tried against him. So only for this purpose we are talking about extradition, but for any other purpose, for recovery of money or imposing fine or imposing any kind of injunction over the website, we can still do it. Doesn't matter where the person is geographically located. The another aspect is theft, the theft by the employees. Theft by the employees. So here, whether we have this bill or not, there are every particular company executes this non-disclosure
confidentiality agreement.
Confidentiality
agreement.
Correct. Yeah, confidentiality agreement and the non-disclosure agreement, and they are bound by it that they cannot disclose it to any third person. So when they move out of the company, they may have some cookies in their phone which will have the data of the company, and which you cannot help. So such data which you inadvertently carry with you when you go out of the company, that such data has to be protected, like you pointed out. Then it cannot be said that amounts to theft, because the backup is already there in the company. So any data in any company is always being backed up. Every second it is being uploaded onto the cloud and it is being backed up. So it is not a case of theft that once this employer takes the data that you are bereft of that data. That is not the case. You still have the data, but where you are aggrieved is that data can be used by that person by giving it to your competitor, or commercially it may not be viable. So that's a civil case that falls as per the contractual obligations between the two. So yeah, like you said, sir, so we need to understand that there might be some data which has to go with the person who's going out of the company. There is no other go. So on yes, sir.
Yeah, see, data where there is potential risk of the data being used to manufacture a product, because that was your idea, your conception, your innovative, indigenous, scientific data. So then there it will amount to data theft. And I have gained experience by doing something in your organization. So that is the experience I will use in my next organization. Tomorrow, that should not be treated as data theft, because that experience is what you will carry. See, data theft is a very loose word which has been factored. It has not been qualified properly.
Correct.
Okay, that needs to be amplified, qualified properly. Otherwise, any experience can be also treated as data theft. I share what is your experience in the previous company. If they ask, I will be speaking it out.
Yes.
In digital era, it's very difficult to say which is not amounting to data theft and which is amounting to data theft. That is, and in some confidentiality agreement, there is a clause where I have also done up to 1 year after the employee leaves. he is not supposed to disclose
Yeah,
or share thing afterwards. He is free. He should not go and even employ with a competitor. Like such
Yes,
things are being put
yes,
in
yes.
the initial stages.
Yes. So on these aspects, you're right. The data theft has to be more clearly and concretely defined in this bill to ensure that only those who are responsible for actual theft should be punished and not the innocent people. But when it comes to non-compete clause and non-disclosure clause and all these things, these are more civil in nature, and the Contracts Act also deals with this. Section 27 is there, and any contract that restricts your employment or profession is a void contract. However, the Honorable Supreme Court and the Honorable High Courts also have said that there is an exception to this provision of the Contracts Act also. So reasonable restrictions can still be placed on that person when he's going out of the termination. So there are settled principles of law when it comes to a person who's terminated. What is the information that he can share with the other company, or what is the information it cannot be shared? These are the ratios that have already been decided by the courts. So we can refer to those things, to those judgments when we are talking about this. But you are right, sir. When we talk about data theft, it has to be more clearly and concretely defined in the bill to ensure that only those who are really guilty are punished and the innocents are not punished.
One last thing, where is the Data Protection Authority going to be located under the bill? If it is located in Delhi, how does common man have access? See, there's no mention about it.
Yes. Sir, in the Data Protection
Consumer
Bill,
Protection Act, CCPA, says Delhi, and regional centers not yet established. Like that, this is also a similar case.
Correct. So, sir, to answer this, so one more issue that you raised is under the IT Act. Any person, a government authority or the authority appointed by government can enter your house and take hold.
69.
Intercept, yes,
69.
under 69. You can intercept and take possession of your computer and extract data out of it, and all these things can be done. But the procedure has not been defined.
Correct.
But in the very same section, it has been said that the procedure has to be defined by the government through rules. So those rules, it's a responsibility of the union government to come up with those rules, and only then this section can be effectively implemented, not otherwise. And even in PDP also, it is only about 60% of the law that is there in the act. About 40% is left open to be devised by way of rules. What is a social media intermediary? There is a threshold, but the threshold will be defined in rules. So till the time we have the rules, we will not know where this Data Protection Authority is going to be located. So we'll have to await for the rules.
My suggestion is Parliament should here afterwards publish the rules before they even pass the law. Otherwise,
yes, sir.
People will not understand what is the hidden agenda which will come out in the rules. Because I think Mr. Satnarayan Gupta is smiling away. I think we should know that this is something which Parliament should hereafter publish the rules along with the draft legislation. So
Correct, sir. That will give us a complete idea. Thank you, sir. It was a pleasure.
Thank you, sir. One last question for the day by Mr. Shashank. You said call recordings have to be disposed of within 6 months. Which section of Telegraph Act or Wireless Telegraphy Act? For court cases, sometimes recordings are required after 6 months. Are they deleted? Further, sometimes these call recordings are stored out of India on VoIP calls. Is it legal?
Yes, sir. So when I speak about 6 months timeline, this 6 months timeline has been given after the usage of the data. But that data, if it is continued to be used in court proceedings for evidence and all those things, the 6 months time will not operate on such facts. It will only operate once you've ceased to have any use of the data. Within 6 months, you have to destroy it compulsorily. The exact provision of the Telegraphy Act, I need to get back. I need to see the exact provision. So right now, I'm not aware of the exact section which talks about this. But this particular section provides for once the function of the data has been exploited and it has been done with, only then 6 months time starts. And after that, you are required to delete the data or get done with the data, and you cannot use it thereafter. On the exact provision, I'll afterwards get back, sir.
No problem. Thank you so much. It's been quite some time since Mr. N.S. Satyanarayan Gupta spoke. I'll just unmute him for a moment to share his view, and then we'll wind up today's session.
All right, sir.
Thank you, Divikram.
Thank you,
I
sir.
was just waiting for your nod. Okay. Thank you, Harish. Okay, nice. Shahbaz,
Yes, sir.
you spoke very well. My
Thank
attention
you,
was
sir.
towards you only today.
Thank you, sir.
Just
Thank
for
you.
1 hour 15 minutes.
Thank you,
You
sir.
have taken a lot of pain in preparation of your today's talk. Now,
Thanks.
now in every, even to breathe, I think your Aadhaar card is required after some time. I don't know. I think Harish may agree on this part. To breathe, we may require Aadhaar card. We are giving the Aadhaar card to in every person, whether LIC or bank. Of course, income tax department, that's necessary. We are giving for every agency, say, give your Aadhaar card, give your Aadhaar card. If they share the information, how to find out whether they have shared the information or not? We are not knowing it. And every day we are getting the phone call, sir, nimge loan beka, sir, nimge insurance beka. Every day, if you say that you are an advocate, then they will keep the phone out.
Yes,
First
sir.
is I say I am an advocate, then they will not talk further.
Correct, sir.
No, is it not the misuse of the share information, sir?
Sir, I'll tell you regarding the Aadhaar card, the Honorable Supreme Court, what it has noted, the alternative to Aadhaar card is passport, driving license, your ration card, or your BPL card, election card. All these things are the alternatives to your identities. There are about 7 identity cards. And at present, there is no system in the government which links all these 7 cards together to say that the collective information is secured. So these all 7 cards are independent in their own respect and they operate in their own zone. They're not interconnected. So what government wanted, and the other thing is all these 7 cards can be duplicated. There is no unique identification number here, and they are susceptible for duplication. However, Aadhaar cannot be, because your biometric is also being fed into it, and your unique number is being given to you. And again, such number cannot be given to your name or with your biometric prints. So therefore, Aadhaar's main advantage over any other identity card is that it cannot be duplicated. You cannot be impersonated. The other main thing is, because there is no interconnection between these 7 departments, the government is not aware who are the beneficiaries of its schemes, where the ration is going. If there is a scheme which is given for the teachers alone, if it is the teachers who are taking it, or if someone is pretending to be a teacher and taking it, or what is it? If it's a old age person scheme, so is it 100% guaranteed that only a 60+ person is availing the scheme, or anyone who is 55 also is impersonating himself to be, or falsely projecting himself to be 60 through a fake card and doing it? And moreover, when there are so many cards, it was seen in multiple locations that one person was found to be at different places at the same time, because he was using different cards at different places. So to eliminate this lacuna and to eliminate this particular difficulty that the government was facing, it came up with this unique identification number. And the Supreme Court has given a phrase also, say it is better than being the best, better to be unique. Unique is more important than being best, is what the Honorable Supreme Court has held in this particular judgment. So therefore, on this ground, the Honorable Supreme Court has held that it is necessary for the government that this unique identification number is there, and there is this only one card and no other alternative is there for the identity purpose in all the government bodies. The Aadhaar card initially required such card to be given in the private institutions as well, which has been read out by Honorable Supreme Court. Supreme Court has held that in private institutions, you are not required to give your Aadhaar card. But when it comes to the government agencies, the government wants to have one point of identification for a person. And it does not want to go between 3-4 other cards to see if it is the same person or not. It is for this purpose that the government is stressing on the fact that it has to be through one card, and the Honorable Supreme Court has allowed. And when it comes to the breach of data which is being recorded, the main data that will be recorded through Aadhaar is the various government offices that you're visiting, the various permissions from the government you will have, the geographical location of you at that point in time. So all this data will be stored by the government agents. The government, I'm sorry, I'm not dealt in detail on this aspect, but this in itself is a separate topic which is worthy of a separate presentation. So the government has satisfied the Supreme Court that the technical precautions that the government has taken are so strong that it cannot be hacked or it cannot be leaked. The information cannot be leaked, and it will stay within the government, and no third party will gain access to it.
Sir, there should be an audit whether there has been misuse or not. There should be an audit.
Independent audit is a good idea, sir. I agree, totally agree. An independent audit to keep the government also in check would be a very good idea. Totally agree, sir.
Okay. Thank you. Thank you.
Thank you, sir.
All right, sir. Thank you so much. On behalf of Advocates Association Bengaluru, Mr. Shahbaaz, my many thanks to you for a very interesting, very informative presentation. Thank you so much.
Thank you, sir. It was my absolute pleasure. Thank you, everyone, for the patient hearing. Thank you.
With this, we'll be logging off today's session.